Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today, somebody's got a lot of questions, and hopefully I'll have some answers. Stay tuned. So I have a question on one of my other videos from somebody who has some questions about the appeal. And I'm going to try to answer those questions one at a time. So the first one is, are matters considered together or separate? And what he says is both JD and AH have filed notices of appeal. However, I'm failing to find any info on what that appeal would look like, such as, 1, are the matters considered together or separate? So let's talk a little bit about how briefs get filed. The person who normally goes first is the appellant. In this case, that would be Amber Heard. The respondent and cross-appellant is Johnny Depp. So what will happen is Amber Heard will file her appellant's brief, and then Johnny Depp will file a respondent's brief and a cross-appellant's brief, which means he's answering the claims that she makes in her appeal, and then he's raising separate points in his appeal. For example, he might raise points that there was never any admissible evidence that Adam Waldman made statements that were defamatory, or that if he did make statements that they were not defamatory in nature. Whatever his points on appeal are, they will be raised in the cross appeal. That's kind of how things are stacked up. Then Ms. Heard will get an opportunity to file a cross respondent's brief and a reply brief. The cross respondent's brief answers Johnny Depp's issues on appeal, in other words, the things he claims the court did wrong in his appeal, and her reply brief deals with the attack that Johnny Depp made on her points on appeal. And then Johnny Depp will get to file a reply brief that deals just with Amber Heard's cross-respondent's brief. So if we diagram it out, it looks a lot like this. And you can see it seems to be a little bit odd how this whole thing shakes out. But generally speaking, what will happen at the appellate court is this. You will have all of these briefs will show up in a judge's chambers when briefing is complete. In other words, when Amber Heard files her brief, they don't take the brief up and leave it with the judges. They wait until all the briefs come in, and then they take them up to the judges. And then that gets to the matter that he asked, are the matters considered together or separate? Basically, yes, they're considered together, but the issues are separate. In other words, it'll all occur in the same analysis, but the long and short of it is that each individual issue will be dealt with individually. What happens if the court orders a new trial based on an issue affecting both parties, but only one of them ended up appealing or raising it in their appeal as a matter to be decided? Well, if the court reverses for any reason, then it has to go back to the trial court. And it doesn't matter who raised the issue. If it was Amber Heard, then it was Amber Heard and the case gets retried. If it was Johnny Depp, that portion of Johnny Depp's claim where he was sued for defamation, that portion alone would get. But if both parties have things that are reversed on appeal, such that the case has to go back to the trial court, usually the court will give some guidance on issues that it feels the trial court may need guidance on. And then he asks, should you have overlooked an area for appeal and the court spots it, will they be allowed to rule on it or even tell you about it? Well, the court does not go looking for issues. While there are certain things that a court can raise, what they call sua sponte, or on its own motion, it's reluctant to do that with issues that are dispositive. For example, one of the issues that it may raise sua sponte is jurisdiction. Several months ago, in an appeal I'm working on, I had a situation where somebody filed a premature appeal. All of the issues in the court below had not been decided, and the court raised that issue sua sponte and kicked it back to the trial court. And that is the kind of thing that the court can look at. But if it thinks, that Amber Heard was treated unfairly on some issue that Amber Heard didn't raise, it won't be able to do anything about it because they deal only with the issues that are brought to them and they decide only those issues because it is a matter of principle that courts do not issue advisory opinions. And then the final question he asks is, Judge Penny consistently denied any request for sanctions even when the court orders were blatantly ignored. Can those decisions be appealed? Not claiming bias, she did it to both sides. Anyhow, would it be possible to address these structural appeal topics rather than the nature of the appeal speculation that is currently abundant? Well, the court could look at sanctions and the fact that sanctions weren't awarded, but only if a party raises it. Now, trial courts are generally given great discretion about what to impose sanctions for and how to address problems with, for example, discovery violations. A lot of claims during the trial that Amber Heard did not cooperate in discovery and didn't provide complete discovery. She wasn't sanctioned for that. Should she have been? Maybe, maybe not. Normally, what a judge does is they rebuke the party who's responsible, but they don't sanction them unless it is clearly contumacious. In other words, unless it comes pretty close to contempt of court, the court is probably not going to issue a monetary sanction. And the reason they do that is because they really want everybody to play nicely in the sandbox. Courts hate it when lawyers take personal shots at other lawyers. And that's just the way courts are. And even though you may feel that the other people were lower than pond scum, it's never a good idea to make that claim in a court filing and especially in an appeal filing because it undercuts your credibility. So hopefully that answers the questions that my good friend here, War on Assange, has. And I will try and get this video out as quickly as possible so I can get y'all some answers. Anytime any of y'all have questions of this nature, I can not only be reached through the comment function on YouTube, but I also have in the About section, I have an email address that you can address comments to me on. And I'm happy to deal with those. In fact, it's really helpful because sometimes it's difficult to make content if there's not something going on. And if you have a random question about the law, I'd be happy to take it on. Again, nothing I say is legal advice. That's what all these disclaimers say. And that's important for me to say because I don't want anybody to think I'm practicing law in Virginia. I'm not. I'm a Missouri attorney, and I don't do Virginia cases. Thanks again for watching. Have a great day, and I will catch you on here next time.